Welcome back to Elevator Paso, guys. We are with Roger Montoya today. Roger, how are you?
I'm well, Caleb. How about yourself?
I'm doing well. Roger is a candidate for district attorney in the 34th Judicial
District of Texas.
There you go. And he's got a platform he's running on that seems to be more with the times and seems to come along at a perfect timing for the changes that our society is experiencing. And we're here to hear a little bit more about this. First of all, tell us a little bit about your experience. You're one of the candidates that has the most experience in this. How long ago did you start doing this?
I've been practicing now for 21 years, Caleb.
21 years, and at some point you worked with our current district attorney.
That's correct. In February of 1999, I was hired by Jaime Esparza to be an assistant district attorney, and I left the office in November of 2002.
Now, your platform seems to be quite a contrast from Jaime's. Was it part of what you got to see there?
Yes, Caleb. As a matter of fact, I had seen some things at that office that I didn't necessarily agree with, but being a loyal employee to my boss, I would of course implement the policies that he had regardless of my disagreement with them.
And the first question that comes to mind, I mean, Jaime has a bit of a reputation of not taking something to trial unless he's 100% sure that he's going to win. Will this be the case about you?
Well, Caleb, no. First of all, in my humble opinion, there's never any guarantee that you're going to win any given case. And in a trial, any given 12 people who will constitute a jury might think differently from a different group of 12 people reading the case. Now, in my humble opinion, especially in cases where there are victims in a crime, say for example, an intoxicated manslaughter case where there's a drunk driver who crashes into a victim, I think that a jury of 12 El Pasoans should get to hear that case whether or not anybody thinks that that's a winner or a loser as to whether or not the defendant's going to be convicted or they're going to receive a serious punishment, a very high sentence of imprisonment in the case.
So we have cases like this, the latest one being this ex-boxer who was in just that situation. And we've seen prior to him where they get away with something as low as probation. How do you feel about that?
Well, again, my opinion is that in such a case, if someone is to be granted probation, I think that should come from a jury of the defendant's peers. If 12 El Pasoans in their collective wisdom decide that any given offender is deserving of a probated sentence, then I think that that's their opinion and it should be respected. But I don't think that kind of thing should come from the district attorney's office in terms of making an offer, for example, for a plea agreement.
Right. Tell me a little bit more about what you're running on and the difference between you and our current attorney, district attorney, and the other candidates.
Well, Caleb, I'm glad you asked that because I think that one really big difference between myself and the current administration is in the way that diversion programs are treated. So, for example, we have in this county, like in most counties in Texas, a diversion program called pre-trial diversion. We call it PTD for short. PTD is a program intended for first-time offenders. And what happens is the diversion part of it is that the DA's office can make the referral directly to the alleged offender instead of this coming from a judge. Probation comes from a judge. PTD comes from the district attorney.
Okay.
So once the DA's office makes the referral, then the offender is sent to the probation department to actually go through the program. All the rules that they have to follow, all the terms and conditions are the same as probation. Once the offender gets through the program and finishes it, and there is a cost associated with it, they have to pay some fees. But once they're finished with their classes, their reporting, and anything else that might be required by the probation department, then they will send a report to the district attorney's office, and the district attorney's office will dismiss the case. However, currently there is a very high price for admission to that program, and an offender is required to sign a waiver saying that they will not seek an expunction of the case from their records.
Oh, wow.
Yeah, see, ordinarily when you win your case, like getting it dismissed,
Right.
the law says you're supposed to be able to get the case expunged from your record, that is removed as if it never happened.
Right.
But the current DA doesn't agree with that part of the law and requires this waiver. If elected, I'll tear up those waivers and I will allow El Pasoans and also people from Hudspeth and Culberson counties, which are also encompassed in the 34th Judicial District, to receive these expunctions that the law always intended for them to be able to get.
That's awesome, and there's so many things that our current administration doesn't really agree with. One of them would be, and this is a hot topic, the marijuana and hemp laws. I know most of Texas has been a bit more lenient towards it now, yet we seem to, in El Paso County, continue to prosecute to the fullest extent. How do you feel about this, and where do you stand?
I stand with the rest of Texas. If elected, I would do what the majority of other district attorneys in Texas have done and stop prosecuting low-level marijuana cases. Now, as we were discussing before we went on camera, the big change in law that happened is that in earlier this year, the legislature passed a law legalizing hemp. Hemp is a cannabis plant like marijuana. However, hemp has an extremely low content of tetrahydrocannabinol, THC, the substance in marijuana that gives a person their high.
Right.
So it's darn near impossible to get high off of hemp, which is why I think the legislature went ahead and legalized that plant. Also because you can make so many thousands of different products that are useful to people from hemp. Now, the difference between the two plants, as we said, is THC content. Hemp has less than 0.03% THC content, and now that's by law. However, to test the difference between two cannabis plants to determine whether it's marijuana or hemp, our crime labs are not equipped for that kind of testing. So that's why most prosecutors are saying, well, it's not worth it to try to prosecute the cases if we don't have lab reports to back up our allegations.
And whose court is it to, or who has the liability of having to prove this?
Great question, Caleb. It's always the responsibility of the prosecutor, the district attorney and his assistant district attorneys, to prove that a substance is contraband. And so it is their responsibility in court to prove, if they allege marijuana, that the plant is in fact marijuana. Jaime Esparza's opinion is that if a defendant wants to raise a defense that no, the plant I had is not marijuana, it's hemp, it's then the responsibility of the defendant to prove hemp. I disagree. I think, not just because I'm a defense attorney, but because of the law, that it's his office's burden to prove that whatever they're alleging, in this case marijuana, that they have to prove marijuana.
Right, and excuse my ignorance here, but how is it that he's able to get away with this?
You know, prosecutors have what's called absolute discretion. That is, no one can tell Jaime Esparza to prosecute a case, and no one can tell him not to prosecute a case. It is firmly within his power under the Constitution to decide whether or not to take any case and prosecute it in court.
Yeah, and again, that seems to have been a bit of an issue in our county. Is there, that remains, is there anything that should or ought to be done about that?
Well, we have the opportunity to do that in March and November. In March of 2020, the political parties are going to have their primary elections, and the voters will get to decide who is going to be the Democratic nominee for District Attorney, 34th Judicial District, in the November election of 2020. The opportunity there is to elect a forward-thinking DA who can then change these policies. For example, tear up those waivers on PTD, stop prosecuting low-level marijuana cases in line with the rest of most of the rest of Texas, and that would be me.
Right. And what else makes you different from everyone else?
Well, my 21 years of experience are the most of any current candidate. December is the filing deadline to enter the race, so it's still possible someone with more experience could enter the race, but right now I'm the most experienced. I have the benefit of having tried over 85 jury trials, and I think you're going to find that's the most of any of the current candidates. I've been in front of that many juries, so I know what I'm doing. I have the benefit of having practiced in a lot of different areas. I've practiced in criminal law, family law, probate law. I've done some civil cases. I've done a wide variety of different types of cases, and I think you'll find that my opponents don't have quite that type of experience.
And so, aside from the marijuana laws, the drug issue has been prominent in our county, and you have some experience as a DA as well, as an assistant DA, that is, in that department. Tell us a little bit about what you learned there and how you're gonna bring that in to cause that progress we need.
Thank you for asking that question. So, my observation was with low-level possession cases. Let's say, for example, possession of cocaine less than 1 gram. Okay? Obviously, that's a personal use amount type of case. In my experience, if we ever put someone in jail for that type of offense, that offender was doing one thing, waiting to get out for his next fix.
That's right.
So, in my opinion, what needs to change is stop treating cases like that as criminal cases and more like public health cases.
I see.
And when that person does come into the criminal justice system, instead of just treating them like a criminal, we need to treat them also like a patient and see to it that a person like that gets treatment so that they're not just waiting for their next fix.
So we've proven beyond a reasonable doubt that the war on drugs does not work. Tell us how it is that you would work with the community to bring these programs about. How would you implement this so that they're able to go and get the help they need as opposed to sitting in jail?
Well, it's going to involve training assistant DAs to spot these cases, to work with other agencies in order to get persons the treatment that they need. It starts with making such recommendations to the courts. More and more of our courts have programs within their budgets called drug courts, for example. And those drug court programs are specifically intended to provide guidance and treatment for people who suffer from drug addiction. So I think we need to make more and better use of those types of programs.
So we have about 2 to 3 more minutes. Tell us something that we haven't discussed that we should know about you.
Well, I am a son of El Paso. I was born and raised here. I attended Cathedral High School. I graduated in 1991. I then attended the University of Notre Dame and graduated with honors in 1995. And then I immediately went to the University of Texas School of Law and graduated in 1998. I sat for the bar exam that summer and received my passing results in November of 98. I've been practicing law ever since.
That is great. Well, thank you so much for your time. I hope we're able to continue to follow through with you, see how your campaign is going, and take it from there.
Thank you, Caleb. I really appreciate your time.
Thank you.